and had an affair with Nathan Wade. The judge wrote this: "There's a significant appearance of impropriety that infects the current structure of the prosecution team, and there's no choice but to change it." We carried it all live. Remember these fierce moments in the Willis-Wade courtroom case.
You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
Fani and Wade claimed their relationship began after she hired him in 2021, to the tune of $750,000. However, testimony and text messages from former friends and colleagues shredded their timeline.
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her?
No doubt.
Okay.
The text messages go like just date, and that's from Miss Merchant. Miss Merchant says, "Do you think it started before she hired him?" Mr. Bradley says, "Absolutely." Now, absolutely is not a speculative word.
Senior correspondent Jonathan Seri, who has been on this case throughout, is outside the Fulton County Courthouse in Atlanta, Georgia. Jonathan.
Hi, Harris. Judge Scott McAfee has given DA Fani Willis a difficult choice to make, but most legal analysts assume that she will choose to stay on with her office and instead take the option to ask Special Prosecutor Nathan Wade to step down. That would allow Willis and the rest of her office to proceed. The judge was unconvinced by defense allegations that Willis and Wade improperly benefited financially from a previous romantic relationship that involved cruises and other travel. But Judge McAfee did express concern that allowing the couple to continue prosecuting together this case would lead the public to question whether their relationship had resumed. McAfee writes, put differently, an outsider could reasonably think that the DA is not exercising her independent professional judgment totally free of any compromising influences. As long as Wade remains on the case, this unnecessary perception will persist. Steve Sato, former President Trump's lead defense counsel in the Georgia case, had this reaction. While respecting the court's decision, we believe that the court did not afford appropriate significance to the prosecutorial misconduct of Willis and Wade, including the financial benefits, testifying untruthfully about when their personal relationship began, as well as Willis' extrajudicial MLK church speech, where she played the race card and falsely accused the defendants and their counsel of racism. He's referring to DA Willis's speech at Big Bethel AME Church back in January. She didn't mention the defendants or their attorneys by name, and in his ruling, Judge McAfee writes that it did not cross the line to the point where it denied the defendants of their right to a fair trial or require the DA's disqualification. But it was still legally improper, McAfee writes. Providing this type of public comment creates dangerous waters for the district attorney to wade further into. End quote. Harris, back to you.
Jonathan, thank you very much.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.
Hope you enjoyed that latest clip from Fox News. Now we'd love to dive into it with you and hear what you think. So let's strike up a dialogue in the comments section. Don't forget to smash that like button, follow us, and hit subscribe to stay updated with more content like this. In a recent turn of events that should concern any patriotic American who values justice and impartiality in the legal system, there has been a significant revelation regarding the current prosecution team involved in a highly charged political case. This case is not just about legal minutia, it's about the integrity of our judicial process and, by extension, the very foundation of our democracy. The spotlight is on Fulton County District Attorney Fani Willis and the emerging details about her past relationship with a hired prosecutor, Nathan Wade. The defense's reaction to the decision regarding this matter is apt, pointing out the stark appearance of impropriety. We witnessed fiery moments in the courtroom, a battle not just over facts, but over the fundamental trust in our legal system. At the core of the issue is the timeline of the relationship between Willis and Wade, with allegations that it predates his hiring in 2021. Testimony and text messages from former associates suggest that their involvement began as far back as 2019, casting a long shadow over the objectivity and fairness expected from those who wield prosecutorial power. What's particularly alarming is the alleged evidence of financial benefits from this relationship, which includes a substantial amount paid to Wade to the tune of $750,000. When judicial figures profit from relationships that may influence legal proceedings, every American should be concerned. As a conservative Republican and an ardent supporter of former President Donald Trump, I see this not merely as a cause for pause, but as a glaring red flag that demands action. It's a moment that tests our commitment to the principles of justice and due process. Let's not mince words. These aren't circumstances that we can afford to take lightly or dismiss as inconsequential. It's true that the presiding judge offered Willis a difficult decision, but potentially allowed her to bypass the full ramifications of the situation by giving her the option to simply ask Wade to step down. This barely scratches the surface of the potential conflict of interest and does little to reassure the public that their concerns about impartiality are being taken seriously. The facts laid bare demand a higher standard than what's been offered. If Willis and Wade were involved financially or romantically, there's more than just a hint of bias, in fact. There would be a crater-sized conflict of interest, and both should step away from the case to preserve the sanctity of the judicial process. In closing, the pursuit of justice is not a game of optics, nor a theater where perceptions should be managed. It is a solemn undertaking that leaves no room for doubt, for even the slightest compromise can unsettle the scales of justice. We must ensure that fairness is not only done, but is seen to be done. That is the bedrock of our legal system and the bedrock upon which trust in public institutions lies.